This is our second special topic for the day. This is the Maximum Participation Amendment. I'm sure if you practice family law that you are familiar with this amendment because it comes up a lot. What we're going to consider today is how we got to where we are and where we're going with this amendment. Well, as you may know, recently, in 2011, the legislature amended the statute governing the structuring of parenting schedules. Well, I wanted to include this topic in the presentation today because it's something that keeps coming up in my practice with pretty great frequency. There's been language in recent courts of appeals decisions and even from the Tennessee Supreme Court which you might find useful if you're on either side of an argument arguing for equal time or for limited time. And with that in mind, the one thing that should stand out to you is that the Maximum Participation Amendment has proven to be very confusing to the courts. Well, let's look at this amendment and see how the courts are dealing with it. Well, here's where you'll find the amendment. This is the statute that governs comparative fitness analysis for the structuring of parenting time arrangements. We have Tennessee Code annotated before the amendment, and the amendment itself is in red here. Well, let's look at the language. The new language in the amendment states that the courts shall take into account the child's best interest, and then they shall order a custody arrangement that permits both parents to enjoy the maximum participation possible consistent with the comparative analysis factors. Those 10 factors that the legislature says that the court must weigh when considering the best interest of the child are enumerated in the subparts, and I won't go through them all, but they consider things like love and affection, the disposition of the parents to care for the child, the stability of the family unit, mental and physical health, although there's been some recent case law concerning the mental health aspect of these factors. We look at the preference of the child if the child is over age 12. Now there's currently a bill in the legislature that's trying to lower this to age 10. So we may see some changes in that this next year. We also look for evidence of abuse. We look at past performance of parenting duties, and I'm sure you're familiar with that, whether or not a parent has been to the doctor's office with the kid or has gone to the school meetings and that sort of thing. Well, finally, our amendment adds two more considerations, and they're here at the bottom. We look at the location of the residence of the parents, and we look at the child's need for stability and all those relevant factors. I think that's a classic legislature restatement right there. Well, now we've got courts that are having to grapple with the intent behind this amendment, and it's proven to be a bit baffling. Well, historically speaking, I think you could say that the amendment is indicative of a trend. If we went all the way back to the 1950s, the prevailing view at that point in time was the tender years presumption. Well, with that in mind, perhaps the difference is clear because we've come a long way from presuming that mom should automatically be awarded custody if the child's under the age of 7. We don't really even use the term custody too much anymore. Well, we've had courts acknowledge that parents thrive or children thrive when they have the influence of both parents in their life, lacking some seriously unusual circumstances. And for some time now, courts have been utilizing this best interest test to make custody determinations. And that's resulted in more individualized results. But, however, life tends to dictate that we can't have an ideal balance. Usually one parent's going to get short end of the parenting time stick, just because you've got things like school and extracurriculars, work, and that sort of thing that interferes. So, considering that our statute already instructed the court to make a determination that's in the child's best interests, and that the amendment just states that maximum participation is to be considered in light of those best interests, then I'm not sure that you can say that there's really been a substantive change of policy here. Well, we'll see what the courts have to say. Well, for the last 2 decades or so, we've had groups like Fathers and Families that have lobbied hard to get equal parenting time bills introduced into the legislature. And in particular, until 2011, the House Children and Family Affairs Committee had considered something called the Equal and Fair Parenting Time Act. The Senate has considered similar bills to that as well, but without such great names. So what most of these bills had in common was that they sought to change Section 36.6.106 by inserting language that there shall be a rebuttable presumption that equally shared parenting time is in the best interest of the child. And then in order to come off of equal time, a party would have to show beyond a preponderance of the evidence that equal time would not be in the best interest of the child. We even had some bills that went so far as to require that parenting time would be equal unless the courts found that one of the parents was unfit. Well, as you can imagine, this would pretty much eliminate any sort of squabbling over parenting plans unless you had one parent that was somehow unfit. Well, there was one more thing that these bills had in common, and that's that none of them ever made it out of committee. Well, in 2011, the equal time groups had almost pushed one bill into the General Assembly. And just as that bill was approaching that mark, the Tennessee Bar Association decided to intervene. And so the Tennessee Bar Association introduced a compromise position. We're going to see Representative Vance Dennis here explaining the TBA-authored amendment that we've now come to know as the Maximum Participation Amendment.
This bill makes a short but significant change to our existing custody statute in relation to custody determinations in divorce or other child custody matters. Basically stipulates, as reads in the bill, adds one sentence to the statute, says in taking into account the child's best interest, the court shall order a custody arrangement that permits both parents to enjoy the maximum participation possible in the life of the child, consistent with the factors set out below: the location of the residences of the parents, the child's need for stability, and all other relevant factors.
Just for clarification, Representative Dennis, we have talked about this before. I just want to go on record. Now, this legislation has nothing to do with the equal parenting bills that have been brought up before. Is that correct?
No, it's not directly related to that in any way, and it doesn't specifically mandate some of the things that were very contentious about some of those prior bills. It does direct our courts, however, to within the existing standard of what is in the best interest of the child, when they're making that determination, to do their best to maximize the amount of time that each parent can spend with the child, consistent with the existing factors and the existing standard of what's in the best interest of the child.
Now, I've shown you this terribly interesting video, and I'm going to show you one just like it from the Senate to illustrate that even at the inception, we had confusion over whether or not this constituted a change in policy. Now here you heard Representative Dennis offering the amendment as a short but significant change to the statute. However, when he's questioned about the relation of this bill to equal time, Representative Dennis makes it clear that this amendment directs the court to do their best to maximize each parent's time, consistent with the existing standards and consistent with the best interest of the child. In other words, the best interest standard that governed before still governs. Now, candidly, I've talked to Steve Cobb, who works with the TBA, and he helped author this bill, and his take on the amendment was that it wasn't intended to change policy, but it was intended to remind the court that they need to tailor-make each parenting plan. Well, ultimately, this bill makes it out of committee and passes the General Assembly with absolutely zero discussion. So we're going to take a look at the companion bill as it makes its way through the Senate. There was a little more discussion there. We've got Senate sponsor Andy Burke, who's now our mayor in Chattanooga, and he gives an identical introduction to the one you've just heard. So instead of going through that again, I'm going to go straight to the comments, and particularly one from Senator May Beavers. Now, Senator Beavers is going to question the purpose of this amendment, and she'll voice her concern that it confuses the courts. Then you'll see Senator Burke respond that the bill does nothing to change the existing comparative fitness analysis. Let's take a look at that.
Thank you, Madam Speaker. We already set out in the law the factors that the court can consider, and now we're telling them, and I honestly believe, looking at those factors, the court is going to determine what is in the best interest of the child as we've directed them. But here we're telling them that in addition to that we have to consider the maximum participation in the life of the child. Some parents don't deserve that. I think this is confusing. It's going to be confusing to the courts, and with that, Madam Speaker, I'd ask that the members vote against this bill. I think it's a bad bill.
Thank you, Madam Speaker. Again, I would ask the members to vote for this bill. What we're doing is we're keeping these numerous factors in, but the practitioners in this area have believed that this will encourage the courts to do what is in the best interest of this child, of these children, and ensure that these factors are interpreted to permit the maximum amount of time of each parent with the child. And with that explanation, I renew my motion.
I think Senator Beavers makes a good point. She says that the existing factors already instruct the court to determine what's in the best interest of the child. But now the courts are going to be confused because they have to maximize the time within those factors, and that might be contrary to the factors. Well, Senator Burke, we heard, responds that we're keeping the factors in. We're still looking at the best interest of the child, but he says that this emphasizes to the court that they need to interpret the factors to permit the maximum participation of each parent. Well, that's not confusing at all, is it? Well, let's look back at what we've heard so far from the legislature. All right, we've heard that the bill maintains the best interest standard. We've heard that it would maintain the trial court's discretion to craft parenting plans. And we've also heard that it retains the existing comparative fitness analysis. However, the amendment emphasizes that judges should attempt to maximize time for parents within those constraints. Now, Senator Burke did not address the concern that this was going to confuse the judges about their responsibilities. So we have to ask ourselves, how does this clarify the court's responsibility? I don't think that it does. And I don't think the court decisions thus far show that it's clarified anything. Well, the good news is that if you have to make an argument for either side, equal time or something less, you've got ammunition on both sides. And oftentimes that ammunition comes from the same case. So we're going to see that when we look at the first case that provided substantive analysis of the maximum participation amendment. Let's take a look at it. You've heard K.O. mention this case before, Roundtree v. Roundtree. Now, this was a case from last year, but it's the first and it remains the only case to provide substantive analysis of the maximum participation amendment. Now, just quickly to go over the facts, father was injured in an accident prior to the marriage, so he's wheelchair bound when he's getting married. He's unable to work full time. Well, after the parties married, they divorced then 9 years later, but they've got a 2-year-old daughter at this point. Well, father had been caring for the child during the day. Mom worked most of the time, so when she came home, she helped out on nights and weekends. Well, we end up having a disagreement over preschool. Mother wants the child to start preschool at age 3. Father wants the child to skip preschool and then start kindergarten later. Well, he's going to take care of her during the day. Well, our trial court rules that father is being overprotective. They adopt mom's proposed parenting plan and make her the PRP. They give father alternating weekends and 1 overnight during the week. Well, the traditional caregiver father appeals. He doesn't like this. Our Court of Appeals say that the long-standing policy in Tennessee, codified by Section 366401, pointed out that the parent-child relationship is of fundamental importance and that the relationship between the parent and the child should be fostered unless inconsistent with the best interest. The court then says that the change to 366106 merely emphasizes that existing policy. And that would seem to agree with the statements of Representative Dennis and Senator Burke that this is not a substantive change. And of course, if it only emphasizes an existing policy, then it can't be a substantive change, can it? Well, not so fast. The court's going to flip-flop on us and turn the ruling on its head. And yes, I did that. All right. So now the courts must now give each parent the maximum amount of time possible. This is from the same ruling. Must now. Well, I was under the impression that this was long-standing policy. The amendment only emphasized that policy. Now the court's saying that we're completely changing the prior approach. It says that the amendment makes the paramount consideration ample time with both parents. So I suppose now we're going to throw out the best interest standard. They point to Tennessee Code Annotated 366401A, saying, in any proceeding, the best interest of the child shall be the standard by which the court determines the party's parental responsibilities. Right after they say that. Well, Senator Beavers may have been right when she argued that the amendment would confuse the court. Well, our Court of Appeals vacates the trial court's permanent parenting plan and remands it for a new permanent parenting plan. They say there's no basis to restrict father's time given the new amendment. They say that given the express legislative preference that parents receive maximum amount of time possible with their children, that there was no basis to restrict father's time. They say that the new parenting plan should ensure that the child enjoys maximum of parenting time with both parents. So I'm left scratching my head over this one. We've got the court flip-flopping on the question. Well, the good news is that as a lawyer on either side of this case, you can use this case. On the one hand, we've got the amendment merely emphasizing long-standing policy. It's not a substantive change. On the other hand, the amendment changes everything and now we're advocating for equal time. So this makes some good language if you need to advocate for equal time. Let's look at some cases that have come out since Roundtree. Now again, Roundtree gives us a very bipolar approach, so we're going to see that in the resulting case law. I want to look at 3 cases in the appeals courts, one that is an equal time case, one that is a bipolar split position like this one, and then one that is a limited time case. And then finally we'll see how the Supreme Court has treated it. All right, Van Erbs v. Jackson. In this case, we had unmarried parents that lived together, and they had one child. Well, after they separate, they establish paternity. It's a really long hearing. There's a lot of facts, and at the trial, they actually called 14 witnesses to underline the deficiency of each other. Well, the trial court looks at it and makes father the primary residential parent, but says that it's in the child's best interest to have equal time with both parents. And this is the western section, and they acknowledge that Roundtree falls on sort of both sides of the questions. Our facts here, this is post-divorce, so I don't have a lot of juicy divorce facts for you, but it's worth noting that these parties were pro se. There were a lot of wild filings. Everybody was trying to disqualify each other's lawyers and the judges and all that good stuff. But we had a minor child who was not yet in school. At the time, mom and dad live about 100 miles away from one another. And we had a weird split in the plan where mom would get 217 days, dad got 148 days. Now he exercised those days on Thursday through Sunday. Those are Thursday through Sunday evenings every other week, and then Tuesday through Thursday evenings on the alternate week. So it was a difficult schedule. We had the kid driving back and forth about 200 miles a week. Well, the trial court hears mom's testimony and exhibits. Interestingly enough, dad refuses to testify at the trial court. So, seeing kindergarten in the future, our trial court judge finds that there's going to be a material change of circumstances, and that change is occurring, and they adopt mom's plan. So mother ends up with 283 days, dad gets 82. He's lost about 60 days. So father appeals. Well, on appeal, the court looks at whether the trial court was in error by failing to consider father's maximum participation. The court looks at the new amended 6106 and all those factors that come after it. And they point out that the Roundtree case stated that pursuant to the statutory emphasis on maximizing each parent's amount of time with the child, that Tennessee courts must fashion parenting plans so as to provide each parent with maximum time. Well, then the court steps back and says, however, as we also noted in Roundtree, the child's best interest must guide the court's judgment. The needs of the children are paramount. The desires of the parent are secondary. So if you were arguing for equal time, you'd want to pull that language out of the first part, saying the courts must now fashion parenting plans to give maximum time. However, if you were arguing the opposite side, you want to go to the second part that says that the needs of the children are paramount. So we're going back to the best interest standard. Well, that's confusing. Our next case is going to give us an example of a compelling argument against equal time. There we go. This is the case of Connor. Now, our parents couldn't even agree on how to spell Connor's name. Some folks said E-R, some folks said O-R, but the court chose Connor O-R. Well, this is a case where the parents' availability became the primary best interest consideration. We had a never-wed couple. They had a newborn child. Both parents lived with their parents. Father worked as an analyst. He owned a store, so he was working about 8 to 5 Monday through Friday, and then at the store Thursday, Saturday evenings he worked. So he was working over 60 hours a week. Mother worked at a daycare, 35 hours a week. The child attended daycare at the same place, so she's been the primary caregiver this whole time. Well, this case has come to us after 2 remands, and at this point in time, Mom is arguing that she's the primary caregiver. She never refuses Father's visits, and she's able to spend more time with the child. Well, Father argues that he wants equal time, even though he can't exercise it. He argues that his parents and grandparents are there to care for the child. Well, the trial court keeps Mom's plan. They adopt Mom's proposed parenting plan, saying that Father's availability is contrary to the child's best interests. Well, Father appeals. He cites Roundtree. He's advocating for the maximum participation possible. Well, the appeals court notes that this consideration was meant to foster a relationship between parent and child. In this case, the court found that Father would be absent during his parenting time, not actually caring for the child. They say that it's in the child's best interest that the parents raise the child, and thus they uphold the trial court and Mother's plan. So here we see best interest trumping maximum participation. So we've seen appeals court cases that can help the argument for equal time, those that could hurt the argument for equal time, and two cases that could help both sides. Well, not surprisingly, the Supreme Court has weighed in, but only a little bit. And we'll see this in this case. And you heard K.O. talking about Armbrister. Just quickly, this was a case that came on a material change in circumstances question, but at the end of the opinion, we do have a little bit on maximum participation. So just as a recap, we have a married couple with 2 minor children. Mother has significantly more parenting time. Father moves further away, but his work schedule opens up. So he's got Fridays now that he can exercise with his children. Well, the trial court modifies the plan to give father more time, finding that he can now spend more time with the children, and that is in the children's best interest. Well, mother appeals. The Court of Appeals reverses the trial court, finding that father had failed to establish that moving his practice was a material change that affected the children in any meaningful way. And they say that it's not enough distance to necessitate a change. The extra Friday doesn't matter, and so they reverse the trial court. Well, father petitions up to the Supreme Court, who reverses the Court of Appeals on the change of circumstances question. But for the purpose of maximum participation discussions, we have to skip all the way to the end of the decision. In dicta, the court says that by giving father more time, we allow father to move closer to the statutory goal, which is to allow both parents maximum participation possible in the lives of their children. I think that language is very important if you wanted to make an equal time argument, because within the best interest of the children, we've already come to the maximum participation. Unless, of course, the statutory goal is equal time. And in that case, the only logical conclusion is that if we're moving closer to the goal, we're moving closer to equal time. Sounds like an implicit endorsement to me. But the court then says in the footnotes, in footnote 22, that this legislation was not a change in policy. It was a more specific statement of the policy already expressed in other statutes. And here they're referring back to that 36.6.401. Well, as we learned in Roundtree, that statute emphasizes the importance of fostering parent and child relationships, but it names the child's best interest as the paramount consideration. So we have both sides of the argument coming from the Supreme Court. If you're arguing for equal time, cite the dicta. If you're arguing against it, cite the footnotes. And that seems to bring me back to where we were in the legislature in 2011. We had the sponsor stating that this was not a change in policy. It was a re-emphasis of the importance of having both parents in the children's lives. So to sum it up, what was the legislative intent of the Maximum Participation Amendment? Not a confusing question at all. Let's see what Representative Dennis has to say.
This bill adds 1 sentence to our existing child custody statute. In taking into account the child's best interest, the court shall order a custody arrangement that permits both parents to enjoy the maximum participation possible in the life of the child, consistent with the factors set out below, location of the residences of the parents, child's need for stability, and all other relevant factors. This doesn't change the existing standard as far as determining what's in the best interest of the child when making a custody decision. Just provides a little direction to the courts, as I indicated earlier, and I renew my motion.
Well, it doesn't change the existing standard, and it provides a little bit of direction. Not confusing at all. Well, I predict that we're going to see a lot more on this in the future. And we'll go with that to part 2 of the Family Law Update.